wherever you may be. This is Dr. Olu Asekun podcast. We are starting early today because of scheduling conflict. Please, can you help me put it? Yes, good afternoon. Thank you for joining. This is Dr. Olu Asekun here. Today we are starting 1 hour early because of scheduling conflict. I have to be in court this afternoon, and it's in person. It's not a virtual court. It's in person, so I have to be physically in court. So the only way we can have the podcast today is to start early. And of course, the podcast is also going to stop at 12 on the dot because I have to drive about 45 minutes to court, and the hearing is at 1 o'clock. So, if you are not online yet, please join us. If you are online, invite your family, friends, colleagues at work. As usual, we start with an update between last week and now, things that have happened as regards immigration in the United States. So that is where we are starting from. So the last 1 week has been very, very interesting, extremely interesting. There are so many updates. I know a lot of people have received so many calls regarding the issue of U.S. citizenship for children that are born here. I want to state categorically that the court has not ruled on that issue. The Supreme Court did not rule on that issue because the Supreme Court decision from last week, a lot of people misunderstood it. It wasn't a decision as to taking citizenship away from children who are born here by undocumented parents. That was not the decision. The decision is more about injunctions, power of the federal court to grant a nationwide injunction. And what the Supreme Court said, even though I disagree with them, but what they said was that a district court judge cannot grant a nationwide injunction, especially when the case is not a class action. So, in other words, what they are saying, the way they interpreted it, is that if I, as a person, as Dr. Olu Asekun, if I sue the Trump administration over a matter, I live in Dallas. If I sue at the federal court in Dallas, that issue concerns me. So if the district court judge is going to stop the administration, is going to grant an injunction, the injunction should only be in Texas. They are saying that the injunction should not be nationwide because I'm the only party. Somebody in New York has not sued. Somebody in California has not sued. Somebody in Washington, D.C. has not sued. So they are saying that the district court judge should not have granted a nationwide injunction in such a case. However, they gave exceptions to class action. Class action is different. When you file a class action, you are a category of people are representing the entire people that are affected. And I can tell you, after the Supreme Court decision, some people are already putting together a class action. But of course, class action requires approval by the court, so it has not been approved yet, but they are working on it to make it a class action so that when an injunction is granted, it becomes nationwide. So that was all the Supreme Court decision was all about. The Supreme Court has not said anything about whether children born here by undocumented parents, whether they are citizens or not. That issue has not been dealt with because I've received so many calls, so many messages asking if their children are now U.S. citizens or if the citizenship has been taken away. No, nobody's citizenship has been taken away so far. So that issue has not been decided. The issue is still pending in court. So that clarification is very, very important. The next thing that I want to quickly talk about, since we have very limited time today, uh, is that, again, in this administration's uh, now notorious pattern, the Department of Justice, the Office of the Attorney General of the United States, last week again, they decided, was it last week or Monday? No, last week. They decided to file a lawsuit against all the federal judges in the state of Maryland, claiming that they are preventing them from deporting people. They are not allowing them to carry out the president's instruction relating to immigration. So they filed a lawsuit against all the federal judges. The interesting thing here is that, I do a lot of federal litigation. I sue the government all the time. So I know this. The interesting here is that, by law, when you sue the United States government, or you sue an agency of government, or you sue an employee of the United States government, by law, that lawsuit is supposed to be defended by the Attorney General of the United States. By law, you are supposed to serve the Attorney General of the United States. So if you file a lawsuit, if you don't serve the Attorney General of the United States, that lawsuit will be dismissed. So it is the Attorney General that is supposed to defend the U.S. government, that is supposed to defend the agency of government, that is supposed to defend all employees, all federal employees in their official capacity. The issue now here is that the same Attorney General is the one suing them. So if the one that is supposed to defend is the one now filing the lawsuit, the question is, who is now going to defend them? Can you see how ridiculous, how unprecedented this administration is when it comes to immigration? I mean, there's going to be a legal, I don't even know, legal confusion, or what am I going to call it? When the Attorney General is the one that is supposed to defend all federal judges, the same Attorney General is the one now suing all federal judges in the state of Maryland. So who is going to defend them? Are they going to create a kangaroo defense team that will go to court and agree to whatever they want? Or are they going to now appoint independent lawyers to go and defend them over a case that they file? Will that even be legal when the law is very clear, the Constitution is very clear, that when you sue the U.S. government or an agency of government or an employee of government in their official capacity, it must be defended by the Attorney General of the United States? What a legal confusion. We are in an unprecedented time. We don't know where this is going to end, but we are here. Another update. Well, I still don't know whether this will become law or not, but yesterday, the Senate of the United States, they passed this, how did Donald Trump describe it? Big, beautiful bill. This big, beautiful bill. They passed it, the Senate passed it. Of course, they passed what was modified, slightly different from what the House of Representatives initially passed. So now it's going back to the House of Representatives. So if the House of Representatives pass it the way the Senate passed it, then it means that the president is going to sign it into law. Why is it concerning? Why is it an issue relating to immigration? It is an issue because in that bill, the Senate approved $150 billion for immigration enforcement. $150 billion for immigration enforcement. I mean, that is ridiculous. That is ridiculous. What are they going to enforce? They are already deporting people. They are already detaining people. They already almost shut down the border. Nobody is coming in illegally anymore. So what is the $150 billion going to do? We don't know yet, but we are just giving you updates. Before I go into the questions, another update that I want to mention is that TPS has been cancelled for Haiti. Haiti. You know, Haiti is a black country in North America. Is it South or North America here? Caribbean, I think. Haiti. So TPS has been cancelled for them. It's going to be effective September 2nd. So if you are from that country, you need to start making plans to look for other means of keeping yourself in status. TPS has now been cancelled for Haiti. Have you started posting the questions? I hope I didn't miss anything. Another thing that was also in the news, I've not actually uh, read this from AILA or from the government myself, but the reason I believe it was reported by NPR, National Public Radio, yeah, that Trump administration is planning to revisit 25 million naturalization cases. Those who receive their citizenship, they want to review everything. So if anyone is found to have obtained citizenship by fraud, then you probably have reasons to be concerned because they want to revisit everything right now. Okay, let's go into the questions for today because we really have very, very limited time. Is that the very first question? Okay. Good morning, Dr. Olu. God bless you, sir, for your time and good heart. Thank you. Amen. I'm a father of a U.S. citizen. My daughter submitted my I-130 petition 11 months ago to USCIS, but haven't had anything yet. Will advise on USCIS processing time. That's immediate family. Well, I don't know. Is this person applying from? Okay. At the time of filing the I-130, my daughter did not submit Form I-485 for adjustment of status. Can she proceed to file it now or wait till the approval of the Form I-130? Actually, that was going to be my question, whether this person was inside the U.S. or outside the U.S. Now that it has been confirmed that you are inside the...
There's more. It's a long question.
Okay. Sorry for bothering you with all these questions, sir. Myself and my wife entered the U.S. with a B1, B2 visa last year, April. My B1, B2 visa expired 21 August 2024, but the I-130 was filed August 17. Please move it again. I see that there are more questions. Am I out of status in the U.S.? Will the present travel restrictions on Sierra Leone affect my pending I-130 petition with USCIS? Please move it again. Will USCIS approve my I-130 petition without submitting the I-485 to adjust my status? My daughter is married to a U.S. Navy officer. Can her husband influence my pending I-130 petition? Well, I think you have to stop it there because I may not remember all the questions if I have to move it down a little bit so that I'll come back to the. Okay. Let me just give a straight answer because of time. Since you are already in the US and you enter the US legally, you can go ahead and submit the I-485. In fact, not even you can. You should go ahead and submit the I-485. It is very, very important. You should go ahead and submit it for both you and your wife. Why is it important? It is the I-485 that will keep you in status, not the I-130. So because your I-94 already expired since last year, currently you are out of status. So it is the I-485 that will keep you in status. Just go ahead immediately. Go ahead, submit the I-485, submit affidavit of support along with it, submit medical examination along with it. So once you submit it and you get the receipt notice, that is what keeps you in legal status. Also, submit application for employment authorization and travel documents so that at least you will be able to get social security number and be legally present in the United States. it is actually the I-485 that will keep you in status. So it is not even an optional thing. Go ahead and submit the I-485, because if you don't, the I-130 that is pending will not save you if you ever encounter immigration. What will save you is the I-485, and you don't need to wait for the approval. You can go ahead and submit it now. So once you package the I-485, make sure you include the receipt notice of the I-130 so that they will know that you have a pending petition. That is what will actually keep you in status. Your next question, whether you're somebody in the military, can you please move it back to that question about the military?
Oh, the Navy.
The Navy.
This one.
Okay. My daughter is married to a U.S. naval officer. Can her husband influence your pending I-130 petition? No, sir. He cannot influence it. But again, the I-130 petition does not keep you in status, so you don't even need to request any influence. Go ahead and file the I-485. That is what will keep you in status. That is what will protect you, and that is what will actually make your I-130 expedited fast. So if you file the I-130 alone, stand alone, as you have done, if your petition falls into National Benefit Center, they may not approve it in the next 4 years. So that's not even an option. Go ahead, submit the I-485. One, that will keep you in status. Two, you will be able to apply for employment authorization and travel document, and you'll be able to apply for social security number and legally be able to work and live in the United States without any problem. Next question, please. Is that the beginning? The mistake from the...
Yes.
Okay. Mistake from USCIS on my EAD card. My lawyer returned the card 7 months ago and haven't had anything back. Is there a follow-up?
No, that's it.
Well, I don't know what the question is. I don't know. I mean, since this person has a lawyer, I think
Maybe they
it's...
want to know why it's taking too long, or if it's.
I honestly don't have control over that, but
Yeah.
there are steps that the lawyer can take to get it expedited. I mean, if it is their error, if it was, you can't just return it. I believe there are procedure for returning it and getting it approved. To the best of my knowledge, we always get it corrected within 3 months, I believe. Yeah, typically it should have been corrected within 3 months. But again, I don't know what the lawyer did or didn't do. So please move to the next question.
Hello, everyone.
What about the one before that? Have I answered
No,
that?
that's from us.
Oh, okay. Hello, everyone. Yeah, hello too. Yeah, good day, sir. I'm on F1 visa. Oh, since this person mentioned F1, that reminds me. When I was mentioning the update, yes, there's also two important updates that I need to quickly mention before I go into answering this question. It is just the F1 thing that reminded me. There are two important things that you need to pay attention to, especially if you are a student. Either you are already on F1 or you are planning to apply. One, social media. It is now mandatory. It's not optional. It's now mandatory for anyone applying for F visa, which is academic student, M visa, non-academic student, or J visa. If you are applying for it, you must make your social media public. That is one. The second update, and the most important one, the Trump administration is now considering having an expiration date on student visa instead of the DS, duration of status. As at today, anyone who is on student visa, their status do not expire until they graduate. That is why it is called duration of status. So even if you enroll for a 4-year program, if it takes you 6 years to complete, For as long as you are enrolling in school and you are not violating your status, the F1 keeps you going. There is no expiration date. Now they want to make it the same way all the other visas are, because every other non-immigrant visa, they have expiration. If you're on H1B, it is valid for 3 years. If you're on R1, it is valid for 2.5 years. If you're on L visa, it is valid for 1 year. If you are on what kind of visa again? Maybe O visa is valid for 3 years.
L1.
Yeah, I've mentioned L1. So all these visas, all these non-immigrant visas, they have expiration. Even if you are on which one does this entertainment use?
P.
P visa. They also have expiration. The only visa, the only non-immigrant visa that does not have expiration is student visa. But now the Trump administration is considering also setting an expiration with it. So that means if I don't know how many years they are going to set it, because it's still going to go through a lot of process before it is approved, because that one will require them to publish it in the Federal Register. It will require them to give the public an opportunity to comment on it, to either approve or disapprove, and then thereafter they will review it, and then they will come up with a policy. It will still take time before that is enforced, but it is something that can still happen before the end of the year if they decide to follow through. In 2019, Donald Trump's first administration actually attempted to do it at the time. They started the process, but when he lost the election in 2020, the Biden administration decided to stop it. They didn't follow through. But now they are trying to bring it back. So that is the update on student visa. Now let me go back to the F1 question. Good day, sir. I'm on F1 visa. I submitted my OPT renewal request, and USCIS is asking me to provide pay stubs and employer details, which are non-existent. RFE is expected to be submitted September 2nd. What are my options? I don't know any option. They are not going to approve it, because if you are on OPT by student status regulation, I believe you are required to get a job within 90 days for the OPT to be valid. So if you didn't get a job, how are you going to request an extension? So they will probably not extend it if you didn't get a job. However, if you got a job but your employer didn't give you pay slip, maybe they didn't put you on payroll, maybe they were treating you like a contractor, 1099, then you will need to show can you please let me get, I thought I have one here. Water, please. You will need to show either your tax return, because remember, if you are on OPT, no matter the kind of OPT, at least your OPT will have been valid for at least 1 year. So if you are applying for an extension of your OPT in 2025, that means you had OPT in 2024. So you are supposed to have filed tax return in 2024. So even if your employer didn't give you a pay slip, if they didn't place you on payroll, if you have other evidence of remuneration, I mean, if they were paying you by check, if they were paying you by cash, whatever it is that they were doing, for as long as you get paid, you are required by law to file tax return. So you can use evidence of your tax return as proof. Thank you. You can use your tax return as evidence that you are working, because if there is no evidence that you use the OPT, it means that the OPT is not valid. It means that you are out of status. That is the regulation. Next question, please.
The
Okay. Good day, sir. God bless you richly for all you do. Amen. This is a kind of follow up to my first question. I married to my US citizen wife in June 2017 and I got my 10-year green card 2018. You can't be married in 2017 and get a 10-year in 2018. That's not possible. You probably got a conditional green card in 2018. But let me keep going. So in 2023, I applied for my citizenship, but on the interview day, the immigration officer questioned my divorce document, and some technical questions, like maybe I still support my divorced wife. So they said I should go and support documents like bank statements. So they said I will be rescheduled for another interview. So on second interview, they brought out things this time. It's my divorce document that they are not confused. I was there with my lawyer. It took us about 4 hours going forth and back. So my lawyer suggested that we withdraw the application, which we did, and advised me to go back to Nigeria and get divorce papers done. So I traveled to Nigeria High Court and get done this time around. But during this time, my American wife was sick and told me she wants a divorce. And after the divorce, few months later, she passed away. So now, what do you advise me to do, sir? Because I got my 10-year green card since 2018 and I got married June 2017.
You might remember we have seen that before, where they approve 10-year when it's supposed to be a 2-year.
Yeah, they can still revisit it if it was
Yes.
approved in
Yes,
error.
it's a mistake. It's an error.
Well, this person is really in a very difficult situation. I have to be honest with you. You are in a very, very difficult situation. And I don't think this is the kind of questions that you should be we will be able to address properly on a podcast. There are so many legal challenges here. First and foremost, I will even have a lot of additional follow-up questions. When you say that you went to Nigeria, you fixed the divorce, how did you fix the divorce? Was it that you filed a fresh divorce, or was it that the previous divorce that was corrected? Because the difference between fixing a previous divorce and filing a new divorce is that whatever you do after your marriage to the American citizen, it means if the divorce was after your marriage to the American citizen, it simply means that that marriage to the American citizen was void ab initio. It was not valid from the beginning. So if it was not valid from the beginning, the law is that you cannot build something on nothing. Nemo dat not quod non habet. You cannot build something on nothing. So if the previous divorce was not valid, it means that the new marriage to the American citizen was equally not valid. Whether she is dead or alive, that will not affect anything. In fact, the fact that she is dead even makes it worse, because if she were to be alive, it depends on the state where you reside. So certain things may still be possible in some states. Every state is different when it comes to divorce. The law in Texas is different from most states when it comes to divorce, especially when it comes to issue of a previous marriage not being properly terminated. In Texas, if your previous marriage was not properly terminated, that marriage is void. But if you now go ahead and properly terminate it and you come back and both of you and your American wife, you both agree to remain married and you continue to represent yourself to friends and family that you are husband and wife under Texas law, that marriage becomes valid again. But the validity will be from the date that the divorce was fixed, not the date of the previous marriage. So there are so many issues here that I may not be able to address it properly during a live podcast like this. Like I said, there are questions that I have that we may need to you may need to provide answer for before I go further. There are a lot of other things that can also come up. I mean, I don't know if you will be eligible for 237A1H waiver in this situation, because I don't even know if you have a qualifying relative. Again, there are so many things that we don't know. So, but legally, there are lot and lot of legal issues that come up from these questions that you have raised. So I would suggest that you probably maybe schedule a consultation appointment where we will be able to have one-on-one uh, session, and I will be able to ask questions and then be able to advise you properly to see if there are any options that you have. But right now, looking at the information that you have provided, you are in a very tough situation. But it is not something that cannot be fixed. Next question, please. Good morning, sir. Good morning. Thank you too. Please help me watch the time. I have to leave here at 12 o'clock. Okay. Can a naturalized American citizen work in a paramilitary of his country of birth? Example, Nigerian Customs Service or Nigerian Immigration Service. Oh yes, It doesn't. Nigerian Immigration Service, yes, you can work. What you cannot do is to join the military, because if you join the military in another country, what if there is an adversarial situation between that country and the United States? For example, a naturalized Iranian, for example, with what happened recently between the US and Iran, if a naturalized American were to be in Iran military, that would be a ground for denaturalization. You know that when you are during naturalization, there is these questions about what do you call it? Those 5 questions on N400. Oath of allegiance, yes. Are you willing to take the oath of allegiance? If the law permits, will you be willing to bear arm on behalf of the United States? So if you are now bearing arm on behalf of another country, that will be a violation of the oath of allegiance. But if you are talking about customs, I mean, those ones they don't go to battle, they don't fight. Yes, I believe that you can work for the customs of another country, but you cannot work in the military of another country. That will be a violation of the oath of allegiance. Next question, please. Thank God for what you are doing. We thank God too. Sir, when will R1 visa become current, or what priority date are they now? Can you quickly help me check the priority date? The last time I checked, and I think it was yesterday, for people who are here, it was unavailable. But for people who are outside, it actually moved almost 2 years from 2019 to 2021. You can check it again. I think that was what I think I checked it this week. And it was, yeah, please confirm. For those who are outside, the priority date moved from 2019 to 2021. Yeah, that was what I saw the last time I checked. And for those who are in the US, it is still on what month in 2021? February 2021. Because I know that previously they retrogressed back to 2019. So they now moved to 2021, that's a progress. But as for those who are in the US and are waiting for priority date, it is still not current. And to the question that when will it become current, that is something I don't have control over. It's a question that I cannot answer. It's a question that even USCIS cannot answer, because the role of determining visa bulletin is given exclusively to the Department of State. And that is why the Department of State release the visa bulletin every month. I'm sure that by next week, probably by the end of next week, they will release the bulletin for August. So, but for right now, for those who are outside, there was a movement between from 2019 back to 2021. But for those who are in the US, it is still unavailable. Next question, please. Good day, sir. May God continue to bless you and your organization. Amen. I sued my US citizen wife to court after my I-751 was denied in August 24. She went to immigration office in January 2020. After she forcefully removed, I assume me, from her house in 2019 April. We got married in August 2017. Part of the reason was that she claimed that our marriage was fraud and scam without any proof. I submitted so many documents of both family pictures, but I was given option to refile based on my divorce in 2021. Suing for defamation, is it a good step because we are genuinely married and lived together between 2017 August and April 2019? Her lawyer wants us to settle out of court. Is that the end of the question? Well, it's a good idea, even though the same thing that you are trying to achieve in a civil lawsuit, you could have achieved it in a divorce. If you file for divorce, or even if she's the one that filed for divorce, you can actually prove that your marriage was not fraud. This I've done on behalf of so many clients. I mean, there are so many things you could do. If the wife was alleging that the marriage was fraud and then filed for divorce, or if you are the one that filed for divorce, all you needed to do was to request a deposition, put her in the under oath, and ask specific questions. And of course, you also come with documentary evidence to rebut our position, to show that your marriage was legit. So you could do that in a civil suit too, but you could also do it in a divorce suit. So, but yes, it's a good thing for as long as you have your evidence. So if the lawyer wants you to settle, you let the lawyer know that your condition, I mean, she will have to retract a statement that the marriage was fraud. She will have to retract it for you to settle. Otherwise, I will not settle, especially if you have the evidence. Next question, please. Please, sir, if someone filed since 2019 and I've done several renewal of EAD and I've done 3 interviews and up till now I haven't heard from USCIS, what do I do? So what is it that was filed? Was this a family-based petition? Was this asylum? Was it employment-based? I mean, what was it that was filed? If the look at the name, if the whoever asked the question, if they can send a follow-up to let us know what is it that was filed. So because we don't know what was filed. So if I don't know what was filed, I can't tell you what to do. The next question. My kid's EAD date of birth has an error in it, which I returned last year. I only received for the younger brother while the other was not returned. So I filed and I and the kids for renewal because it expired. Can you please move it forward?
Expire recent. Okay. No, I don't know this. Okay, Fola, yes. Then this is the continuation.
Okay, so it means it expired April. I only received mine EAD but didn't receive the kids' own. What can I do? I filed for renewal since December. Well, do a service request. Check the processing time. If it is outside processing time, then you do a service request. Especially if this is supposed to be a correction. If it's a correction, then you do a service request. Even if it is not a correction, if it's a correction, you can do service request without waiting for the processing time. But if it is not a correction, if it is just a renewal, you have to check the processing time, because without the processing time, they may not even allow you to submit a service request. So you can submit a service request and then follow it up. Even though this application too, we only talk about EAD. I don't know what was the petition based on, because if it was based on asylum, you can actually use the membership of ASAP, since this is your child's first EAD, since she has not received one before. Next question. Thank you for all you do. Thank you too. I filed for asylum within 2 months of my 6 months I-94 validity. The application was without brief, and if I submit a new application, will it not affect my legal process? Can you move it forward? Oh, will it not affect my legal, is it process or presence? Okay, legal presence, as this is 11 months of my arrival in the United States. What does it mean by brief? Is it talking about affidavit? Well, irrespective of whatever it is that he's talking about, if you have not submitted a brief or affidavit, as the case may be, that has nothing to do with the processing of the asylum. So if your application has been pending for 11 months, that means that you are already eligible to apply for employment authorization. So go ahead and apply for employment authorization. And the good thing is that right now they've gone back to last in, first out. So you may even be called for interview any moment from now. But go ahead and submit application for employment authorization. In addition, get your affidavit or your brief, as you call it, get it ready, so that whenever they invite you for interview, you can submit it in person. I believe that this is an affirmative asylum, since the person just talked about entry, I-94 and all of that. So yeah, just get your affidavit or your brief, get it ready. Whenever they invite you for interview, you can submit it in person. But in the meantime, you are already eligible for employment authorization.
If they filed online, they can upload it if they want to.
Yes, if your application was also filed electronically, if your story is ready, you can upload it. But to be honest with you, if I am your lawyer, I will tell you not to. Get it ready, but don't upload it. That would be my advice if I'm your lawyer. Because once you submit it, that's it. You cannot change anything in the future. You cannot modify anything. Even if there is a change condition, you cannot. Once you send it, it's there for life in your record. So the next question. Good job and thank you for all you do. Thank you too. Is immigration still granting motion to reopen and terminate removal? My lawyer filed for me a year ago and still haven't heard from immigration. No, they don't anymore. Apparently, you are probably new to our podcast, because at the beginning of Trump administration, those were the first set of things that they changed with barrage of executive orders. So they don't grant that anymore. But they still grant motion to reopen. What they don't grant is termination. Motion to reopen, yes, they still grant that. In fact, I still have, this week, I still have a client who was ordered removed in absentia. We filed a motion to reopen, and on Monday this week, the motion to reopen was granted. Yes, they still grant motion to reopen. What they don't grant is the termination aspect. So even if you have a basis to apply for adjustment, just file your motion to reopen and request the case to be processed at the immigration court instead of USCIS. They don't grant termination anymore, at least under this administration. That is part of their initial executive orders. The next question. Oh, this was from last week. Okay. Sir, is the income used for affidavit of support gross income or income after tax that is used for eligibility for sponsor? It is adjusted gross income. If you look at your tax return, there is a portion of it. There is I don't know the number in my head, but if you look at your tax return, you will see what is called adjusted gross income. That is the figure that they use. If you look at your tax return, the form 1040, you will look at all the different columns. Usually it should be on the first page, but sometimes it may get into the second page depending on how lengthy your tax return is. But it's going to be between the first and the second page. So look at all the columns. You will see adjusted gross income. That is the figure that they use. Please move to the next question. Good day, sir. Thanks for all your help on YouTube. You're welcome. Please, we, myself, husband, and second son just got our asylee 10 years green card in January 2025. My first son, U.S. citizen, is 21 years old. My first son, U.S. citizen, okay, they repeated it, is 21 years old. For us to become citizen, should he file for us now or should we wait until after 3 years? Your reply will be highly appreciated, sir. Let me see. The asylum was granted in January. Yeah. So that means before he can apply for green card based on the asylum.
The 10 years green card is what was granted in January.
Oh, 10-year green card was granted in January. So that means he has to be 5 years before he can apply for citizenship. So that would be 26, 27, 28, 29, 30. Then January, that would be December, November, October. Yeah, he will be eligible for citizenship by October of 2029. Now, since you already have a green card, it doesn't make sense for your U.S. citizen child to petition for you, because if your U.S. citizen child petition for you, what you will be filing will be an application for green card, and that application will be denied because you are already a permanent resident, except if there is a missing information. But based on this information you provided, it simply means that you are already a U.S. citizen and you are already a permanent resident. So in the category of asylum, you have to be a permanent resident for 5 years. However, you can submit your application 3 months before the 5 years. So if your U.S. citizen child file a petition on your behalf at this time, it's going to be denied because you're already a permanent resident. So a permanent resident cannot be filing another application for permanent resident. But even at that, assuming that it was not even denied, if your son were to file a petition for you right now, at least no matter how fast, that petition will still take about 3 months. And then after you get your green card based on that petition, you still have to wait 5 years again for you to be able to apply for citizenship, except if your son is in active military duty. Now, if your son is in active military, he doesn't need to file a new petition for you. You can still apply for citizenship based on this same green card that you have on asylum, because when you are going to apply for citizenship under that category, you are not going to be selecting the option that says I've been a permanent resident for 5 years. You'll be selecting an option that says that I'm a immediate member of an U.S. military active duty serviceman. So that is the point. You don't need to, your son does not need to file a fresh petition on your behalf. Next question. Good day, attorney. 360 was approved, but I-485 is pending because of NTA hearing in November as a result of denied I-130 in the past. Can you please move it up? Is that, yeah. But my mom is applying for visa from Nigeria, DS-160. My question, is it okay for her to have my name on her application as someone she's coming? Can you move it? Coming to visit and stay with, even though I have a felony that is under probation. Secondly, is it okay to travel by air to New York from Dallas with my situation? Well, let me take the last question first. As far as traveling from Dallas to New York or New York to Dallas, for as long as you have real ID, compliant driver license or ID, yes, you can travel. There is no problem with that. As far as your mom mentioning your name at the embassy, that is actually something you have to do, because if you don't and they find out that she has a child here, that may even be the basis of a denial. That may be the basis of a denial. She has to actually mention your name, because I am not current with DS-160 right now, but I know that there used to be a question that asks whether you have anybody who is a family member in the US. I don't know if they still have that question. So it's a question she will have to answer truthfully. So if she didn't answer it truthfully, that in itself may be a ground for denial. On the other hand, the issue of the felony, that may be a little problematic. Well, I don't know the details. I don't know. Because you have VAWA, you have 360 that was approved, you may be able to apply for a waiver of ground of inadmissibility, because you are still going to face a ground of inadmissibility based on the felony conviction. And because you have VAWA approval, you may be able to apply for a waiver using yourself as a qualifying relative, especially if the conviction has to do with the abuse. But I'm even surprised. Maybe the fact here is maybe is not clear enough, because I'm surprised how you are able to get a VAWA approved with a felony, because one of the requirements of VAWA is for somebody to prove good moral character. So somebody with a felony will have a hard time proving good moral character, except if the felony was as a result of the abuse or part of the thing that led to the abuse, or it is the abuse that led to the felony, whichever the case may be. But as to whether your mom should mention your name, that is a requirement. If she didn't do that and they found out that you are here, that in itself will be a ground for denial of the application for visa. Good. The next, okay, this is a comment. Good morning, sir. Good morning, too. Next one. Hello, I'm a U.S. citizen. My child came and spent some few weeks in the U.S., went back to Africa to continue with school. Can I apply U.S. passport for my child abroad who qualify under INA Section 320? Well, INA Section 320 has its own requirement, so I don't know if your child meets that requirement, because I do know that if you are going to apply for American passport without applying for naturalization, you have to show that you are living together. You have to show that you are living together. So if you are here and he is in Africa, I don't know how you are going to be able to show that. But you may be able to show evidence of custody too. Well, don't let me jump into a lot of assumption. I don't know if you are together with your spouse, that is the father. I don't know if the father is also a U.S. citizen. So if you are together and the father is also a U.S. citizen, to prove living together may be a little easier, because even if your child is in school, for as long as you still maintain those parental control, you are the one that pays the school fees, you maintain parental control over the son, you may still be able to show all those things. But if the father is not a U.S. citizen, if the father is not here, then you may have some challenges, because it will require you to show that you are living together with that child and you also have custody, or you have a permission from the father before he will be able to apply for passport abroad.
2 minutes.
Okay.
12.
2
Okay.
minutes. Yeah.
Okay, thank you.
You're welcome.
Okay, next question. Can I adjust status? I live in Florida. 2023 Biden parole cut short. I-94 expired, but I have valid TPS, August 2025. Wife LPR filed I-130, January 2025. Priority current. Is priority current for LPR for January 2025? Can you please check? I don't think so. I don't think it is current, but I'm not sure. Priority current, medical done. Can TPS bride adjustment? Bridge adjustment. The issue here is that you have to trace your legal status from the date you enter. Let me look at it again. When did he enter? He just said live in Florida 2020. I don't know when he entered. Because for you to be able to adjust with an LPR spouse, you need to show that from the date
I don't see it
that you...
current.
Yeah, I don't think it is current.
Shows September
You
1st,
should look at
2022.
F2A.
Yeah.
Yeah, I don't think it's
2022.
2022.
But you can use, it's according to the USCIS website, you can use the dates for filing. And that date is
Date for
March-
filing visa application, what's that date?
March 1st, 2025.
Oh, okay. Then
Yeah.
he can apply
That's-
on that basis.
uh-huh.
Okay, he can apply on that basis. But the issue here is that I don't know when you enter the US, because for the purpose of adjustment in this scenario, you have to prove legal status from the date you enter the US. So let's assume this person entered the US in 2023. Before the expiration of the I-94, he was granted TPS. Then the TPS is still going to expire in August of 2025. In that scenario, can you apply for adjustment? Yes. But if, for example, you came in 2022, I-94 expired, then you got TPS, maybe in 2024, you already have a period of unlawful presence between 2022 and 2023. So if you apply for adjustment, they will deny it. So your option is go back to look at the date that you entered the US and trace if you have filed something. If at any point you have something that is pending, then you can apply for adjustment of status. Otherwise, you just have to wait until your wife becomes a US citizen, and that will eliminate all this waiting period. I think I will have to answer the very last question because I will need to leave now. It's already 12. So which one is the last one that I need to...
I'm coming. I think this is the one.
It was I submitted
I
I-130.
submitted I-130 for my mom, but it was denied because USCIS claimed that my birth was not registered at birth. So they doubt my mom is the biological mom. I'm doing a DNA. I'm a U.S. citizen. Is that it, or is there any?
That's it. Yeah, there's nothing else.
So what's the question? Well, the only thing I will tell you, DNA, do a DNA and then get secondary evidence of birth. The issue here is that for immigration purpose, DNA by itself may not be enough. So if you don't have a birth certificate that was registered early, use a secondary evidence. Secondary evidence may be baptismal record, school record. I'm sure you went to elementary school, and of course they will list who your parent is. Early childhood pictures. Maybe when you mark your first year birthday, 10-year birthday, your first day of school, all those things. Maybe picture of you and your siblings and all of that, your school record, your health record, immunization record, all those secondary evidence. Then testimonial evidence, people who are older than you who can testify to your birth, who can say that they knew when you were born, this was your mother and all of that. So in addition to all of that, then you can do a DNA, then it will be approved. Well, I will have to go at this time. As I said before, the only reason we moved the podcast back today is because at least I'll be able to spend 1 hour. I have to be in court in Dallas this afternoon. I'm still going to drive 45 minutes to court, and the case is coming up at 1 o'clock Dallas time. So I will have to leave right now. I wanted to encourage you to not give up. This is a trying period, but I can assure you this time too will pass. So I hope to see you again next week. Until then, remain blessed. This is